Welcome to the Family Law Now podcast. I'm Russell Alexander. I've been practicing family law for over 20 years. We serve clients during separation and divorce, and we upload videos twice a week on interesting cases and keeping up to date with respect to changes in the pandemic. Today, we're going to discuss a deadbeat dad's failure to pay child support and being incarcerated for 4.5 years. It's a controversial decision for some coming out of Nova Scotia, released recently. And this particular father failed to pay over $247,000 and was found to be in contempt of court. So that's our subject matter today. Thank you everyone for joining us. But we've assembled a bit of a dream team here. So I want to welcome our guests. Margie, you want to start?
Yes, thanks, Russ. My name is Margie Primero-Pimentel. I am an associate lawyer here with Russell Alexander Collaborative Family Lawyers. I've been a lawyer 19 years as of next month, and I've been practicing family law for 14 years. So that's a little bit about me.
Goes by quick, eh?
Yes, it does.
Brittany, you want to go next?
Yes, thank you, Russ. Hello, everyone. My name is Brittany Whalen. I am an associate lawyer with Russell Alexander Collaborative Family Lawyers as well. I practice primarily in the area of family law. However, I also have a background in criminal, human rights, and civil litigation. And I was called to the Ontario Bar in 2016, and then I was called to the bar in the province of Newfoundland and Labrador in 2017. I've been practicing family law since 2017.
Welcome, Brittany. Thank you for joining us this morning. Rick, you want to go next?
Hello, everyone. Thank you, Russ. My name is Rick Peticca. I practice in the areas of matrimonial and family law, and I've been practicing family law exclusively approximately 14 years this June. And I work for, I'm an associate lawyer here at Russell Alexander Collaborative Family Lawyers.
The best of the best joining us today. It's really quite an honor. So we've got this decision. We're going to break it down into a couple chunks. So we're going to talk about the facts, we're going to talk about the law, and we're going to talk about the outcome. You know, it's kind of shocking. Somebody's jailed for 4.5 years on an issue of child support. This decision certainly has gotten a lot of attention in the media, and it's gotten us thinking about it's a fairly extraordinary remedy to put somebody in jail. We don't see it too often, and certainly not for this length of time. So let's get into the facts here. What happened in this case?
So the facts of this case, as Russ said, are very interesting. Just a bit of a background. This is a case of mom, dad, and 2 kids. Mom and dad separated in 2007. Fast forward to 2013, and a court found that the dad was underpaying his child support and ordered that he pay retroactive child support as well as ongoing child support. After he was ordered to pay retroactive and ongoing child support in 2013, and for 2 years thereafter, dad failed to pay the child support owing, and eventually accumulated a child support debt of approximately $247,000. You know, and between between 2013 and 2015, he paid only about $22,000 of what was owing, which was originally a hefty child support debt of $269,046. So the court looked at the evidence. The evidence showed that dad was only making what the courts characterized as token efforts to support his children. He essentially foisted his final obligations, his child support obligations, upon his former wife and his elderly parents. At that point, his parents were, his dad was 7 years old, his mother was retired, and from the ages of 6 to 12 until the children were 15 and 19, they went without the proper financial support from their father, who was an IT professional, while they were supported primarily by their mother, who had no professional qualifications. So in 2015, the court found the dad in contempt of the 2013 order. And dad knew about the penalty phase. So after he was found in contempt, he was going to have to appear at a penalty hearing. And he knew about that hearing, but failed to show up. Instead, dad moved to Denmark with his new wife and their son. Dad then stayed in Denmark until he was deported in February 2019, and he was subsequently arrested in November 20, 2020, late last year, under a Canada-wide arrest warrant, and returned to Nova Scotia. So this decision, which was heard on this hearing was heard on December 21st, 2020, so about a month ago, and the court had to decide at that point the appropriate remedy, appropriate penalty for the father's civil contempt. So mom was seeking various relief. She wanted that he be given a 5-year jail term, plus various fines, interest, and costs amounting to an additional $454,000. So that's not including the original $247,000 that he still owed in support. So that is what the case is about.
Interesting, just to cut you off there.
Yeah.
She spent more than she was owed collecting it.
Yeah.
You know, you've got to wonder somehow how this litigation just gets out of control.
Yes, but I
Let's
agree
get back to the
with-
facts. I'm just
yeah.
saying it's an extraordinary amount of money.
It is. But that's where we're at in terms of the factual background.
Right. Great summary, Margie. Really appreciate it. Sorry to interrupt you there.
That's okay.
Okay, Rick, the law, what's going on here? What was the judge looking at when making this decision?
Well, the judge basically, and as Margie said, this was basically a penalty hearing, and the judge was looking at what was the appropriate penalty, because the contempt of court order was already made back in 2015. So they already crossed that threshold in terms of a legal test to determine whether or not he was in civil contempt. Now, the purpose of this hearing was what was the appropriate penalty to give to Mr. Power, and to consider whether there were any mitigating or aggravating factors in coming to that decision. In terms of mitigating factors, those probably would constitute like an admission. And there wasn't an admission. Mr. Power did admit that he was not only that he was in contempt, but that he was remorseful. But the question is, the judge had some concern about the level of remorse, whether he was actually remorseful for his own actions or he was actually remorseful for breaching the court orders.
Remorseful for being in court that day.
Well, and it kind of struck me how the judge wrote the decision, is that he was more remorseful for being caught and being brought back before the court, as opposed to what he had done and his failure not to comply with that order. The judge looked at several factors, including the fact that his current wife and Mr. Power were saying that they were trying to look at selling their home, but they couldn't sell their home, in trying to give the ex-wife or ex-spouse the half of the net proceeds of sale. But the judge kind of felt that he was trying to persuade the wife to take a lower deal on the child support rather than paying what he actually owed. And as well as
being cute, right? He had the assets, potentially he just chose not to access them.
And that's just it, though. The judge found that he had moved a lot of his assets offshore. He was working in Norway. So as the judge said in the last sentence, and I found it very telling, said Mr. Power's remorse is genuine, but it's not clear if his remorse was actually genuine enough for defying the actual court order. She then went on to look at aggravating factors, and aggravating factors can constitute things like lack of remorse, whether there are multiple breaches. And I think most telling in this case is what was the payer's conduct post contempt order. And the fact that, as Margie said, that he moved away to Norway in an attempt to flee the order and try to shirk his financial obligations, I think that was the most telling of everything.
It's almost consciousness of guilt in the criminal sense, right?
That's right, though, and I think that's where the quote unquote, if we're going to use criminal law terminology, the mens rea or the intent
Right.
was there to flee.
So,
So the outcome was the judge found, based on their rules of civil procedure, which allow the judge to make the order, and I think this is what's calling into question. Is the length of the incarceration 4.5 years. And at first, when I read it, I found that a little bit telling, in the sense that it's a civil contempt order, and it's a civil proceeding, not a criminal one. And yet this Mr. Power was given a 4.5-year sentence, but their rules of civil procedure allowed the courts in Nova Scotia to grant terms of imprisonment of not less than 5 years. So,
right. Sorry, Margie, we're going to jump in there.
No, I was just going to make a point about Dad's behavior as well. I found the court found that he and his current wife appear to be deliberately hiding or not really being truthful about the value of their assets. So I think that's also, right. There's a sense of deliberation there, not cooperating, lack of transparency. So I guess that's the only thing I wanted to comment on that.
So Brittany, talk a little bit more about the outcome. What was the final outcome of this decision?
Absolutely, Russ. Thank you. So in the end, the court decided that a stiff penalty was warranted. They found that the penalty had to reflect the degree of responsibility or the lack thereof that the father had taken for his actions. The court, and I'll quote, said the penalty needed to compel respect for court orders, to recognize the gravity of his actions and responsibility, to denounce his conduct, and deter him and others from breaching court orders. So they looked at his past conduct in the 5 years since he had been found in contempt. And despite being periodically employed, he only made a handful of payments for support and didn't make any ongoing support payments.
Yeah, his repayments, or he didn't really have a schedule of payments. It's kind of ad hoc. Really no effort, a genuine effort, I would say, Brittany.
And as we already mentioned, he moved his financial affairs offshore, and that kind of goes to the willful and deliberate intent to skirt his responsibility. The court disbelieved his excuses, as Rick already pointed out, and after noting that the father had already spent 31 days in jail, they ultimately decided that another 4.5 years of incarceration was warranted. That said, they did add the caveat that if the father paid off the arrears, the outstanding money, that he could purge the contempt order and it would cease to be in effect. The court ultimately decided to decline the mother's request for additional fines and costs. They found that it would not assist in the coercive effect of the incarceration, that it would be disproportionate.
Yeah, and we see this a lot in Ontario, where courts remind litigants an order is an order, it's not a suggestion, right? And they need some teeth, otherwise nobody's going to follow court orders. One interesting, just from practicing in Ontario, the general rule, as I understood it, is for non-payment of money, you cannot get somebody incarcerated unless it's through the Family Responsibility Office. But it's non-payment of a civil judgment isn't going to end up having you sent to the debtor prisons in Australia or something like that. But this is slightly different. This is contempt of court. It wasn't necessarily non-payment. And that triggers the court's inherent jurisdiction to enforce its orders. So I think it kind of pulled it out of the legislative realm. It became an issue of the administration of justice. But what sections in Ontario do you guys, I know we talked a little bit about this in emails this morning, but what sections do you think would be relevant when considering incarceration for a matter in Ontario courts?
Russ, if I can offer a suggestion, it's probably section 53 of the Family Responsibility and Support Arrears and Enforcement Act, which provides the guideline to a court what remedy would be available on a finding of contempt.
Right. And I think at a default hearing, the court can certainly order a period of incarceration outside of a contempt finding, but as a part of an enforcement mechanism in Ontario. If you're finding this video helpful, give it a thumbs up in the comments box below. But let's turn to our guests today. So what do you think? Did the judge get it right? Brittany, you want to go first?
Sure. So with respect to the contempt motion itself, contempt motions are a last resort. They're only used when other means of compelling compliance with the court order have been attempted and failed or are unlikely to succeed. So in this case, certainly they tried different things and the father was making it very difficult. He had no intention of following through with his obligations, and there was really no other option. This was a last resort. The standard of proof in a contempt matter is proof beyond a reasonable doubt of each and every element of the claim. So civil contempt, it's quasi-criminal. So there is a presumption of innocence. Basically, the test is there has to be a court order in place, which in this case there was. The terms of the order have to be clear, unambiguous. My understanding from the reading of the case is that he knew. He was put on notice of the terms of the order. There was disobedience of the order. And it was done in a deliberate and willful fashion. So after being put on proper notice, he was given the opportunity to make wholly uncertain defense. He just decided not to. He didn't attend the penalty hearing scheduled back in 2015, and then he didn't need any evidence during the proceedings that took place last year. So in deciding whether or not a litigant has behaved in a willful and deliberate contemptuous manner, the court will look at an explanation. Is there an explanation for their actions? Well, here the father, he offered a couple of explanations, but basically he was trying to blame others. Support enforcement program, the mother in this case, anybody and everybody but himself. That's why the court found that he really wasn't taking responsibility. His only regret was that he was finding himself in this situation. They'll also look at efforts that the party made to ensure compliance. Well, here the court noted that he had only made token efforts, a little bit of support here and there. There was one effort where the father had offered to sell the matrimonial home and give 50% of the proceeds as support payment, but that only really worked out to be about 60% of what was owed. So basically the court viewed that as an attempt to lowball the mom and try to skirt half of his responsibility. The last consideration would be, were there other obstacles not of the person's own making or other reasons that could provide the sufficient excuse for the charge of contempt? Well, here, all of the father's conduct, he was pretty much the author of his own misfortune. Everything he did on his own accord. But that said, if there's any doubt with respect to the necessary elements, they have to be resolved in favor of the person being charged. Here, it doesn't seem as though there was any doubt. I think the court did get it right with respect to whether or not he should be held in contempt. That said, with respect to the penalty, did the court get it right? My answer is one that lawyers love to give and clients don't like to receive. Maybe yes, maybe no, maybe a bit of both, depends. So sentencing principles, going based on my background of criminal law. Basically, you want a sentence to be restorative to the victim. So in this case, you want to make sure that it's remedial in the sense that mom and the children get some sort of relief. You want to compel the father to make payment. It also has to serve the purpose of deterrence, and that's both general and specific. So you want to deter the individual person from not following court orders and not making payments, and you also want to send a message to the public that this isn't okay. In this case, the court highlighted the need to tell the public that court orders must be followed. It's in the interest of the administration of justice. It goes to the heart, the core of our system. But those considerations need to be balanced in the context of a family law case against the best interests of the child. So I will come back to that, but first I'd like to talk a little bit about how this penalty holds up against charter scrutiny. So all laws in Canada have to be legitimate, and they have to be justified under our Constitution, the Charter of Rights and Freedoms specifically. In this case, the penalty involved a period of incarceration, a lengthy period of incarceration. So that automatically triggers charter rights, specifically rights under Section 7, which protect our right to life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice. So that means that, so in this case, his liberty rights are infringed. He's being detained, he's being put into a incarceration facility. And you can only deprive someone of their liberty so long as the law is not vague, it's not arbitrary, not overbroad, or grossly disproportionate. That brings us to Section 12 of the Charter, which guarantees everyone the right to be free from cruel and unusual punishment. So going through this, I did a little bit of a Section 1 Charter analysis to see whether this punishment would be upheld.
That's going back to law school, Section 1.
Back to the basics. So Section 1 of the Charter says that limitations on rights have to be reasonable, and they have to show on the balance of probabilities that the limitation was one prescribed by law, so it has to be accessible, intelligible. Any vagueness or unfettered discretion to do what seems best in a wide set of circumstances is not permitted. Number 2, the limit has to be justified in a free and democratic society. So there has to be a justifiable purpose, and it has to be proportionate to that purpose. The limit has to be as small as reasonably possible. So I think that's where a lot of us are getting stuck. Was 4.5 years appropriate? Was that reasonable? So if we go through this step by step, number 1 under the Oakes test is there a pressing and substantial objective? I think we can all agree that protecting the administration of justice is a pressing and substantial objective. It sends a message that willful disobedience of law and court orders is serious, strikes the heart of the justice system, and it's also a remedial tool that resolve problems that give rise to contempt. In this case, getting the father to pay up. But the means to achieving the objective have to be proportional. That means that the means have to be rationally connected to the objective. So this one here gave me a little bit of pause. In family law cases, the objective of upholding the administration of justice and getting the father to pay, there's a little bit of conflict there. You need to balance that against protecting the best interests of the children. In this case, prison sentences can sometimes affect a family dynamic. The father may not have the ability to pay because instead of working and earning income, they're incarcerated. I believe the individual in this case, he had 3 different children, 2 from the first marriage, 1 from the second marriage. There wasn't really any evidence on the 3rd child in the decision, but how does the father being incarcerated for 4.5 years affect his ability to pay ongoing support, to work and pay ongoing support? And how does the incarceration affect the children generally? Just, this is a very public case. How is that? How are the children going to feel about that knowledge that their father's now in jail and the public being aware of that? Moving on to whether or not the limit in this case is minimally impairing the rights. So we know that in contempt proceedings, courts have wide powers. There's a lot of different things that they can do as a penalty. Here, they opted for the incarceration route. Was that appropriate? Could they have used some other power available to them to accomplish their goals? Arguably, maybe a seizure of assets or something like that, seizure and sale, that would accomplish the goal of having the father pay the money that was due. Perhaps not so much with respect to the denunciation and the deterrence aspect of it, but I don't know that these other options were completely explored in the decision. The next step would be proportionality between the infringement and objective. Here, I don't know that there's a serious conflict. It seems as though they are in line with one another, but the penalty has to be proportionate to the gravity of the wrongdoing, and there cannot be a marked departure from sentences imposed in like circumstances. So in Ontario, we have legislation that limits the possible jail time for non-payment of support arrears to 90 days, pursuant to the legislation that we've discussed. Is there any reason why a court in Ontario, in Nova Scotia, should handle this in a different manner? Obviously, our legislature has decided that there are specific policy reasons for putting a limit on the amount of jail time that can be granted in a family law matter. Some of those I've already discussed. How does incarceration affect a father's ability to pay? How does it affect the family dynamic? So we've carved that out. In Nova Scotia, they have not. So I think there would be some questions surrounding that. Why haven't they? In order for a law to pass charter scrutiny, you have to show that it's not arbitrary. It seems to me that the limit of 5 years in Nova Scotia really gives a court unfettered discretion to award whatever they see fit. So I'll stop there, but maybe give everyone else a chance to talk, and we can come back to this if anyone else wants to add anything.
We sometimes forget in family law that we have a Charter of Rights in the Constitution that supersedes a lot of these decisions. So that's a really good analysis to take us back to, step one in terms of what are our basic rights. And obviously the right to liberty is fundamental to everybody. All right, so we're back. I just want to apologize to our listeners. We're getting a bit of a clicking noise in the background. We were able to troubleshoot it, and I think our audio is much better now. So let's turn to Margie. Margie, do you think the court got it right here?
Yes. Short answer, yes. I believe the court got it right, because the court in this case really had few options to compel dad to fulfill his child support obligations, which, as we know, were very significant. The court also wanted to send a very clear message, and that's orders must be complied with, especially if they are orders for child support. The evidence in this case showed that dad had little regard for court orders, and specifically the court order requiring him to pay child support. And he benefited to his children's detriment from his failure to pay child support. The evidence also showed that he was evasive about the value of his assets, which he could have used to pay his child support. Lastly, he did not seem to take responsibility for his actions. And as Brittany pointed out, he blamed others for the circumstances that he found himself in. So yes, I think the court did, and they had the statutory authority to impose that sentence, and I think they got it right.
Okay, thank you for sharing that. Rick, what do you think? Court get it right in this case?
I agree with both Margie and Brittany. Mr. Power didn't come to court with clean hands, and I think the court had to send a strong message. And as Margie said, that compliance of orders is paramount, and especially in this situation where he was trying to shirk his obligations or his child support obligations. But I echo the concerns that Brittany raised as well. There's a concern with a 4.5-year sentence, not only with respect to a charter challenge, but also probably whether the whether the legislation in Nova Scotia infringes on the federal government's right in the criminal law domain. If I remember criminal law from my first year of law school, an indictable offense is something over 2 years of penitentiary, and I would have preferred the judge to elaborate on why she felt 4.5 years was appropriate, as opposed to any other number that the legislation would have allowed. And even to go with what Brittany was saying, is to expand on why that level of incarceration was appropriate, and in terms of sentencing. Almost like in the very sense what a criminal court does when they sentence an offender, they usually go through the explanation why they feel that sentence is appropriate.
Yeah, good point. I'm going to stir the pot a little bit here. If dad goes to jail, he's not going to earn any income, right? So how's he going to be able to pay his child support?
But respectfully, he hasn't been paying his child support even when he was working.
True, but now he's really not going to be able to pay.
I don't think we're going to hear the last of this, Russ. I can foresee someone's going to bring an appeal on this to the Court of Appeal in Nova Scotia, and maybe even go to the Supreme Court in terms of the sentencing aspect. So I think
also to stir the pot a little bit more, what's it cost to incarcerate somebody in a federal institution? $60,000 to $100,000 a year. We have mom spending $400,000 to collect $247,000. Now we're on the hook. The taxpayer is going to be on the hook for potentially $300,000 to $500,000 to incarcerate this person. Is this the best use of our resources?
Yeah, that's a good point. I didn't really think about that, but that's a really good point. What are the alternatives? No. I mean, I think the courts have again, I'm trying to stir the pot as well. I'm trying to play devil's advocate here, but what else can the court do?
I'm just saying, from a taxpayer point of view, this whole thing sounds ridiculous, how much money people have spent on this case. Really, it ultimately comes down to the children. They weren't being provided for in accordance with the legislation. And I'm being kind of coy here. Of course, I think the court got the decision correct. If this was a desolate dad living on the streets with no assets or no potential to pay the support order, there's no way the court would incarcerate that parent for 4.5 years. I think the judge clearly made a strategic decision that these assets are available after he spends a few weeks in the big house or in jail. They're quickly going to refinance the home and get him out. And that's going to purge his contempt, and the sentence will be over. So clearly, I think the judge was sending a message to the public, like Brittany correctly identified. But I think she tailored this sentence to be so extreme that dad's going to pay up, right? He's not going to sit in jail for 4.5 years if he's got access to a $300,000 house and other assets. So clearly, I think that's what was motivating the court. Had he had no assets, no income, no prospect of income, I don't think judges are going to arbitrarily detain people for 4 or 5 years based on a support order. But that's my own take. I could be completely wrong.
Okay, so in dad's circumstances, the punishment was not excessive because he had the ability to pay. He had a house, he had money, probably some offshore accounts. And that, I believe you sent me an article that kind of said, we're not quite sure whether the ability to purge contempt is an actual consideration or not. It's something that the father argued, hey, I can't afford to purge it, but not sure whether or not that's relevant. But from a constitutional standpoint, it would be, because you look at the penalty in relation to the individual offender's circumstances, but you also look at a hypothetical offender. So would this be appropriate for anyone? You know,
No.
it's like, exactly. So that's where I think the section 12 would be triggered,
I
especially.
don't think if you have the assets or the income, they're not going to pay. Like I said, we're not sending people to debtors prisons in Australia where the judge probably knew this person would pay once they go to jail for a few days.
And also, you're looking at this right now from a family law standpoint, but it's also quasi-criminal. And in a criminal case, you look at all the circumstances of the offender. So here, they're only looking at the 2 children involved. But obviously, there's another child. And presumably, dad was supporting those children while he was living with them in Denmark. And he can't work now for 4.5 years. So I know that in the context of this case, that wasn't contemplated. But because of the criminal nature of this, his circumstances as a whole should have been factored in. And the last thing I just want to speak to is, Margie, you had pointed out the 4.5 years is appropriate. What else could you do? Russ said, 30 days, 90 days in Ontario, that's what we use. And you said, or maybe something less punitive. And you said, well, dad's not paying. So even if he's in jail or not, he's not paying either way. But that kind of brings into question our legislation. If 90 days isn't enough, then what, why did we set it at 90 days? And in this case, after spending 31 days in jail, dad kind of changed his tune a little bit. I don't know how that he was, guilt-stricken and remorseful. He still hadn't purged the contempt, but it seemed like he changed his tune a little bit. How do you maybe spent the 90 days in jail? Well then.
Yeah, I think the overriding concern was the administration of justice and having court orders enforced, right?
Yeah.
That kind of trumped everything here.
And I think like Russ said, I think the dad in this case had the ability to purge that. And I think that's why the judge ordered that sentence, because the judge knew it's going to scare him to pay it.
Yeah. 10 days, he might do 10 days and drag the litigation out for another 2 years. 4.5 years.
Are we at a consensus that in Ontario it's 90 days? There's something else in the support enforcement act that gives you, it's under a different section. It's like non-payment of arrears that says 180 days.
I think the contempt is not reined in by any legislation. I don't think there's legislation limiting a judge's powers once a contempt finding has been made.
So I did look into that briefly, and it looks like the consensus from the Supreme Court of Canada is that, yes, they have inherent jurisdiction, but they can't use that in a way that would fly in the face of the terms of a statute. If it specifically says, here, this is the limit, it can't just arbitrarily do whatever it wants.
It wasn't a sanction for non-payment of support. It was a sanction for contempt of court.
Yeah. So
I think the distinction is you have a civil judgment. You can't enforce it by a jail term, but you have somebody in contempt of court unrelated to the money damages, liquidated damages. That contempt is going to be sanctioned, and that could include incarceration.
Yeah, I think you have to look at the case law. Maybe look at the case law. I know that there's case law that says that the section that you're referring to under the family responsibility FRSEA it has to be in harmony with the family law rules. So perhaps you look at the cases and get back to us. Like that's an excellent question. Like maybe in Ontario, Yeah,
I'd like to be able to tell my clients, well, he better pay up, or he might do 4.5 years. But I don't know that that's the case here. So just tell your clients that there's potential penalty of imprisonment.
Yeah.
And maybe that is enough to compel them to pay their spouse their child support.
And I think Aaron Franks in the newsletter I sent you guys, I think he referred to another case where there was a 4-year penalty.
I think that was Nova Scotia as well.
You guys down east are having a lot of fun, eh?
It's wild. It's wild.
What's that? Get the shriek going. What's that stuff? What's the
screech?
Get the screech going and then start throwing some people in jail.
Gotta do something to stay entertained, right?
Yeah.
No nonsense.
All right, guys. Well, thank you so much. So takeaways from this decision for our listeners. Margie, what do you think?
Follow court orders and pay your child support. If you don't agree, and I'm going to paraphrase what Justice Jollimore said in this case, if you don't agree with an order or you think that it's wrong, appeal it. If your financial circumstances have changed since the order was made, necessitating a reduction of your child support obligation, then bring a motion to change. Just don't do nothing because you are only deferring an inevitable reckoning.
No,
That's my takeaway.
that's a great point. We see lots of, people stick their head in the sand and ignore court process and hope it'll go away, either anxiety or finances or indifference. For whatever reason, they don't respond to court proceedings. But if you don't respond, as this payer did, the court's going to make an order in your absence, and you're probably not going to like it. So that's a great point. It's really important you respond. We get lots of clients who come in who I just had a client like this, received a notice of their driver's license suspension. Mm-hmm. They sat on it for 3 or 4 weeks. You've got a really short deadline to get a refraining order to prevent the Family Responsibility Office from suspending your driver's license. And it's going to take your lawyer a day or two to get the documents in order for the court. So if you've got 21 days to respond, don't give it to your lawyer 5 weeks later. Get on it right away. That's a great tip. Rick, any takeaways here?
I agree with what Margie says. I echo everything basically she said. In fact, those were my points. I guess the last point I can.
Margie.
Sorry, I should have gone last.
I guess the thing I can say is I echo Justice Quinn's comments from Gordon and Starr. Court orders are not made as a form of judicial exercise. An order is an order. It's not a suggestion. Yeah. And non-compliance will have its consequences. So yeah. It can't. He succinctly said it best in that phrase. So,
Brittany, takeaways here?
I would echo what everyone said so far. Until the order is stayed, varied, or overturned, you're on the hook. You have to comply. So make sure that you are being proactive and taking any steps. If you don't agree with the order, you can't comply. Make sure that you're bringing that to the court's attention. And if not, you could find yourself in a very undesirable situation.
Yeah, being a guest of the Queen, so to speak, right?
That's right.
All right, so this has been really good summary. Thanks, guys. Let's give our listeners and viewers some bonus takeaway points. So let's talk about stories of enforcement and support orders, stories of maybe dealing with FRO, which is the Family Responsibility Office in Ontario, and or stories of representing support payers when they go into arrears. We're obviously not going to talk about specific clients, but let's get a flavor in terms of what we experience as lawyers so our listeners can get an understanding. You want to go first, Rick?
Yeah, I think just an observation of enforcement support orders. And as Margie said, if you don't agree with it, bring a motion to change or bring an appeal, depending on the circumstances. But making a payment at times is better than making no payment and yet moving the process forward. I think that's the key thing that if our listeners can take one point away is that it's making a genuine attempt to pay something based on what you're actually making and yet moving the case forward if you disagree with the decision is better than doing nothing at the end of the day.
Yeah, good point. I was before Justice Wood in Aurelia several years ago, and we're talking about arrears, and he said, you're going to go in the parking lot with your client, get his checkbook, and come back with the check for this amount. And then we're going to hear your case after the lunch break. And they call their courthouses in Aurelia cottages. So we're in cottage C. You go out to the parking lot, the client goes, what am I going to do? I'm going to get your checkbook and write out a check. Some judges have very little patience. I had another client, he's maybe $25,000 behind, and the court was going to order a period of 30 days incarceration. And he thought, yeah, that's not bad. I think that's a good way to clear out my arrears. I go, well, when you get out, you still owe the money. It's not like your $25,000 is going to be cleared out. I used to practice, the Oshawa courthouse used to be in the Kenneth Starr building. So on the family responsibility days, they would put all the cases at the end of the hallway, and all the support pairs who hadn't paid would all line up beside each other. Mostly men. There's one or two women in there, but they're all exchanging stories, right? So sitting in the courtroom, they'd deal with them one at a time. It wasn't a public, the judge wasn't hearing it publicly. They would just call the payers in when Fro Counsel would call the matter. And then, we'd have like 7 stories, all the same, all the respondents had shared the same story and came to the judge with the same excuse. So everybody's different, right? I had a client who was ordered to go to jail, and he didn't care less whether he went to jail. He thought that was great. He was going to go in there and sell some drugs and make some money. Everybody's different, but I agree with Rick and Margie, follow the court order. This is serious business. It's certainly not in your children's best interest that you be incarcerated. All right, Brittany, your stories?
Sure. Based on my experience and review of the case law, I would also want to point out that for a contempt order to be issued, it's not necessary to establish that the person actually breached a specific term of the order. It's sufficient to show that they engaged in actions aimed at obstructing the course of justice, or thwarting or attempting to thwart a court order. So you don't have to be caught red-handed breaching the court order. It's sufficient to show that you attempted to breach the order to be found help.
Even your conduct in a courtroom could be considered contempt if you're disrupting the proceeding or arguing.
Speaking from experience, Russ?
No, fortunately not. But the judges have the inherent jurisdiction to control the process and what occurs in their courtroom. And contempt is really the ultimate power of the court. If somebody's disregarding a court order or is disrupting the administration of justice. Thanks, Ulrich. Brittany, final thoughts here. I want to thank our guests for sharing their time with us today. This has been very insightful, trying to get an understanding of this decision, but let's get some final takeaways. Brittany, let's go back to you.
Back to me. Well, in this case, I note the father opted to self-represent for a large portion of the proceeding, and my advice would be to at least consult with a lawyer. Had he have done so, they would have told him the consequences of not appearing in a penalty hearing and what he could be looking at. So definitely, when in doubt, call your lawyer.
Yeah. And the lawyer might prevent the hearing from occurring altogether. You may get it settled. You might enter into a payment plan that can be filed with the court. That's a great tip. All right, who wants to go next? Rick?
My final thoughts are basically, if you've listened to all the good suggestions that everyone on this panel has made, and follow your lawyer's advice, and your lawyer should help you get through it if you should find yourself in the same circumstances.
Yeah, agreed. Margie?
I'm just going to repeat what everyone else said, and just going back, based on my experience, I've had cases where they waited too long, and if they had just called me, and I would have been able to help them avoid having their license taken away, for example. So yes, when there's a court order, if you have any questions about it, if you have concerns, call a lawyer. Let them give you the advice that you need on how to act. And if you find yourself in a situation like Dad did in this, and he potentially would have not been in that situation, like Brittany said, if he had a lawyer. So call your lawyer if you have any questions about a court order, and if you don't agree with it, call a lawyer, see what you can can be done. We're here to help you navigate that.
Yeah, and try to stay current. If you're current in your support and you genuinely have a material change in circumstances, and you're coming to court with clean hands, then obviously the court's going to give you a lot more wiggle room or discretion in terms of accommodating the change. If you just show up or you don't show up and the support remains unpaid for several years, as in the case here, you're really leaving the court with no option other than to step up with enforcement steps. So I want to thank our guests, Brittany, Rick, Margie. This has been a lot of fun. We had a couple technical bumps in the road, but we struggled through it. I want to thank our listeners. If you have any thoughts or questions, leave them in the comment box below. If you found this podcast or video helpful, please give us a thumbs up and let us know. You can share this recording and subscribe to our channel by hitting the bell icon below, and you'll get notification of any new videos that we release. So thank you for listening today. Be safe, follow court orders, and if you don't like the order, speak to a lawyer and get some advice. Have a good day, everybody.